Hearing anything by hearsay denotes that it was not personally heard. Any information obtained from a source that has first-hand knowledge of a fact or piece of information is referred to as hearsay evidence. We can thus infer that it is based on second-hand information. In a court of law, hearsay testimony is typically not accepted. Oral testimony must be direct as per Section 60 of the Indian Evidence Act. The fact must be directly heard, seen, or felt by the individual. For example, I heard from my watchman that a woman was running with a blooded knife. It is hearsay evidence. Generally, it is not admissible in court. A hearsay statement that also contains another hearsay statement is referred to as double hearsay. In court, each layer of hearsay must be approved for admission independently. For example, suppose X heard from Y that B has committed murder, which Y heard from Z. The statement made by X is double hearsay. The reasons for the exclusion of hearsay evidence are: firstly, hearsay evidence cannot be tested by cross-examination. Secondly, it supposes some better evidence and encourages substitution of weaker for stronger evidence. Thirdly, the evidence is not given on oath or under personal responsibility but by the original declarant. Fourthly, it has a tendency to protect the legal investigation. Fifthly, as truth depreciates in the process of repetition, it is not reliable. Sixthly, it increases opportunities for fabrication. It is said that hearsay evidence is no evidence. Direct evidence is more reliable and acceptable in court, but there are some exceptions to this rule. Here, five instances when hearsay evidence is accepted by the court. Firstly, res gestae. The rule of res gestae means the facts which form part of the same transaction. This rule is given under Section 6 of the Indian Evidence Act. The statement of a person may be proved in court through another person who appears as a witness in court if the fact that he states in court forms a part of same transaction. In the case of Shukhar vs. State of Uttar Pradesh, the witness arrived at the scene of the crime on hearing firing and saw that the injured who conveyed the identity of the murderer was admissible under Section 6 since it was a part of the same transaction which was the act of shooting. Admission is also an exception to the rule that says hearsay evidence is no evidence. Section 17 of the Indian Evidence Act defines admission as a statement either oral or in the form of a document or electronic form which gives inference to any fact in issue. If a person in court makes a statement against his own interest, then the court accepts such a statement on the ground that a person shall never make a statement against his own interest. Confession means when a person admits his guilt in the court. Confession has now here been defined in the Indian Evidence Act, Section 24 to Section 30, and it deals with the provisions relating to the confession. If a person gives an extrajudicial confession that is outside the court, it may be proved through the testimony of that person to whom such confession was made. Though the witness did not hear himself or see anything related to the offense, but the confession by a person may be proved through his testimony in court. Section 32 of the Indian Evidence Act talks about the statement of a person who cannot be called as a witness in court. There might be a situation when a person is on his deathbed or suffering from any disability due to which he cannot appear before the court. In such cases, if the person gives his statement to any other person relating to his death or cause of his death, then the person to whom such statement has been transmitted may appear before the court as a witness and give hearsay evidence as to what he heard from that declarant. Evidence given by a witness in one sitting of a case proceeding can be stated in any subsequent proceedings between the same parties, if the witness has died or is for some reason not available. This is applicable for the entries in books of accounts and public registers that can be produced before the court. Though the person may or may not be alive, the statements he made previously in books or registers are admissible in court. So that's all my friends. Hope you like the video, and if you do, then please like and subscribe my channel. It will encourage me to make more videos like this.